other areas of commercial property practice where perhaps some guidance and some advice may be useful. Some of it you may know, some of it you may not know, but we are hoping that at the end of the session today, we'll have given you some useful advice and set out the legal position as we see it. So a couple of housekeeping points. We will be taking questions at the end of the webinar. So if you think of something as we're going through and you suddenly think you want to ask a question, we'd ask that you hold on the chat mode and obviously ask your question at the end. The main body of the webinar will take approximately 45-50 minutes, and then we've got 10 minutes at the end for questions. After the end of the webinar today, my colleague Amy Ellis will send you an email which will contain a recording of the webinar today for your reference, a feedback form. We'd be really, really grateful if you could give us some feedback, and a copy of the slides. I believe the slides have actually been circulated ahead of today so that you can all make copious notes on what we're going to say, which would be great, but you'll have another copy of the slides at the end as well. So let's have a look at the areas that we're going to cover today. So we've broken it down into these areas. So the first section I'm going to do, which will cover key points from the Coronavirus Act 2020 on commercial properties. Graeme is then going to pick up the alternative options for landlords where perhaps the rent hasn't been forthcoming. We've tried to be a bit creative and come up with some alternative solutions for rent payments and recovery options, and to give you a bit of briefing on where those different methods are at the moment. I'm going to pick up again then and talk a bit about insurance. I know we've got some insurance advisors on today, so obviously if there's anything that I've missed, please feel free to put advise at the end. Business rates, again, just obviously that's an important issue as well. Dilapidations, so that will cover what you need to consider as a landlord and a tenant if you have an ongoing dilapidations claim or are considering a dilapidations claim. Again, I think we've got some surveyors on here, so I'm not trying to tread on any toes, but it's just a general overview as to what the key issues might be. And then Graeme's going to finish off by talking about the impact of the Coronavirus Act on landlord and tenant 54 Act lease renewal processes. And finally, if you're a tenant, but also for landlords, what you might need to consider if you are at the point where you might want to exercise a break. And we'll talk about if there are any other ways to bring a lease to an end, given the current circumstances. Okay, so moving on. Okay. Oh, by the way, if you have issues with any sound, Amy Ellis is going to pick up that issue with you directly, and she will email you to talk about any resolutions that may be available to you. Okay. Right, so first things first, Coronavirus Act 2020. So the Coronavirus Act came into force in March, and it had a myriad of provisions affecting lots of different areas of life, and in particular what we want to talk about today are the provisions which cover commercial business tenancies. There are sections in there that cover residential tenancies, but we won't be focusing on those today. So one of the things that you want to consider when looking at the provisions of the Act is whether or not, either as a landlord or a tenant, your tenancy, your business tenancy, is one which is going to be covered by the provisions in the Act. So the relevant definition that you want to have a look at is what they call a relevant business tenancy, and that means any tenancy to which Part 2 of the Landlord and Tenant Act 54 applies. Well, it's quite a clear definition. I suppose the only thought that we had internally was whether or not that's likely to apply to contracted out tenancies, and our conclusion and the conclusion of other colleagues in the legal industry is that it does apply to contracted out tenancies, because in principle, as long as you are occupying the property for a business exclusively for a period of over 6 months, then it is a tenancy to which Part 2 of the Act applies. If you then contract it out, it doesn't stop it prima facie being covered by the Act. So if that is a tenancy which you have, so a relevant business tenancy, then you will be covered by the provisions of the Act. So in terms of looking for potential issues with that, you want to have a look at things like licenses. So licenses wouldn't be covered because they are not for a fixed term. Any tenancy for under 6 months wouldn't be covered either by these provisions. And also if you have mixed use premises, so any premises where there is one lease, but more than 50% of the property is used for non-business related purposes, then again, those aren't tenancies that would be covered by the 54 Act, and therefore they are not covered by the Coronavirus Act 2020.
So I suppose one further point, just kind of, I suppose it's a question in some ways, is do we know what the position is with agricultural tenancies? Because they're not expressly covered either.
Yeah, no, really good question, Graeme. Ordinarily, agricultural tenancies don't fall within the Landlord and Tenant Act 54. They have a separate regime. So because they wouldn't ordinarily fall within the Landlord and Tenant Act 1954, they are therefore not covered by this provision either. So again, any sort of agricultural tenancies, farm business tenancies, so they won't be covered by the Coronavirus Act, but good question. Okay. So let's get into a bit of nitty-gritty. So section 82.1, and this is the key one that most landlords are going to be concerned about. Normally, most leases will contain a provision for forfeiture. So that is a right of re-entry into the property in the event that the tenant fails to pay the rent or comply with the covenants under the lease. So this section states that a right of re-entry or forfeiture under a relevant business tenancy for non-payment of rent may not be enforced by action or otherwise during the relevant period. So we've got a lot of additional definitions in there that I'll just talk through as well. So the relevant period for the purposes of the Act is the 1st of March to the 30th of June. So we're only talking about that period. I was saying before some of you arrived that actually we've been sort of eagerly watching the news to see whether or not that 30th of June deadline is likely to be extended. And to date, there hasn't been any mention of any proposed extension of that, although the Act does reserve the right for the government to make extensions to that date. So the second point to consider is the term of rent. So what is rent essentially is the main headline rent under the tenancy, but it also includes insurance rent and service charge. So if you were thinking that you could still exercise your right of forfeiture if the tenant fails to pay the service charge, unfortunately that's not the case. So anything that is payable under the terms of the lease is essentially within that definition of rent under the Act, and therefore means that you cannot exercise the right of forfeiture in relation to it. Okay. Obviously, one of the things to be cautious of with tenants not paying rent is that there may be a risk that you might waive your right to forfeit if you let non-payment of rent pass by unnoticed. The Act is slightly helpful in this regard because it does actually specifically state that with the exception of an express waiver in writing, no conduct of the landlord during the relevant period will waive that right of forfeiture for non-payment of rent. So that's section 82.2 of the Act.
I suppose one question I had, and I'm sure you're probably just about to tell us the answer, is so we know that enforcement actions, the effect of some enforcement actions that landlords can take is going to be postponed until after the 30th of June. But do we know whether they can kind of issue or commence proceedings in the background now to get ready for after the 30th of June?
Well, funny you mention that, Graeme, because that's what my next slide covers. So well done for that lovely introduction. Yes, I mean, there is nothing preventing the parties from making an application under section 146 now, but these sections, section 82.4 and 82.6 of the Coronavirus Act, state that any applications in progress will effectively be put on hiatus. So even if you were to submit an application for forfeiture, it is effectively, it won't even be looked at until after the 30th of June. So both the High Court and the County Court are going to be prevented from making any order for forfeiture during the relevant period. So that, again, from the 1st of March to the 30th of June. Any orders for forfeiture already made and falling within the relevant period will also be automatically extended. So let's say you've gone to court, you've got your order granting repossession of the property. Again, that's going to be extended until after the 30th of June.
Splendid.
Okay, so those are the key provisions of the Coronavirus Act. So they essentially set out, from a landlord's perspective, what you can't do. Graeme's going to have a look at the other ways rents may be able to be collected if you have a situation where the tenant hasn't paid any rent at the moment. I'm going to hand over to Graeme.
Thank you very much. So pointing out the obvious, just starting at the beginning, there's nothing in the Coronavirus Act which relieves tenants from their obligation to pay rents under their leases. It's not like they're getting an automatic rent payment holiday. And as Becky mentioned in the previous slide, you would have to give an express waiver in order to actually kind of manage to forego the rent, so they don't get an automatic holiday. So what we would suggest as a practical step is that you pick up a dialogue with any tenants that you have a concern might not be able to perform their obligations at an early stage, so you can hopefully then preempt any payment related issues that might otherwise occur. So what we would suggest is to agree a deferment and to then document that in some way. But I'll come back. I'll come to that in the following. I'll come back to that in the following slide. So other things that you can't do right now. Well, as Becky said, that you can't forfeit. So we've covered that, and then the other point is that whereas previously commercial landlords might have used statutory demands in order to incentivize tenants to remember to make them rent payments. For the time being, there has been a temporary kind of cessation on landlord's ability to use those also. Otherwise, there's the commercial rent arrears recovery scheme, which is still available in theory, although you may have some practical difficulties using it, with social distancing and so on. And the other kind of point to kind of pick up about that is that there's been a temporary tweak to the scheme during the relevant period, such as whereas you would previously have needed to have 7 days worth of rent outstanding, that period has been pushed back to, or increased to 90 days worth before you can avail yourself of the scheme. So
that's really interesting, isn't it,
aware
Graeme?
of that.
To that extension is the timing of that extension to 90 days is equivalent to a quarter's rent. That's quite canny of the government to extend that to that level.
Yeah, just as we have a quarter day and people probably not making their quarter day's rent. It'll be interesting to see what happens.
Absolutely. So talk us through what we should be considering about agreeing a rent deferment.
Well, so the thing with this is that what we want, the initial thing to say is that what you want to do is to be careful, and thank you, Nick, for asking the question. We want to be careful to make sure that you agree a deferment and not a waiver. The difference is with a waiver, that's it, it's gone for good, you can't get it back. Whereas with a deferment, if you're careful to kind of set this all out properly, you're only effectively you're just pressing pause on the tenant's obligation to pay the rent. You're saying, well, okay, I accept that you can't pay it right now, but you're going to pay it in the future. And so this is where we would recommend having something in writing between you and the tenant in order to set out how this is envisaged to work. So what would we suggest putting in a deferment agreement? Well, key things. You want to know when you're going to get paid. You want to set that out. You need to agree something with the tenant that's going to be ideally manageable. I mean, for both of you. It would be helpful to set out to make express what's intended to happen in terms of the interest position on the late payment. Is the tenant going to be obliged to pay you interest on the payment in terms with the kind of late payment provisions that will be set out in the lease, or are you going to put something different in the deferment? need to make it express, need to be explicit as to how long the deferment period is going to last. And one kind of general point, but hopefully a useful one, is although often when we see that clients have put things together themselves, that there does seem to be a temptation to automatically put at the bottom of them, rather, signed and executed as a deed. And so that the danger with doing that, of course, is that you might accidentally, if you kind of manage to do this as a deed, create a permanent variation to the lease, which may or may not have some kind of unexpected kind of side effects. So if you're doing this, I mean, the advice would obviously be to take advice. Ideally, this is something that Becky or I could assist you with. Final thing is, it'd be good to set out in the deferment agreement, or which it could take the form of a letter. Set out some kind of consequences, just to set out what happens in the event that the tenant manages to deviate from the agreement, to set out what is intended to happen there. But again, take advice, come back to us. This is exactly the sort of stuff that we can help you with.
I was going to say, Graeme, so we talked quite heavily about what landlords can't do. We suggested that we work as, so landlords and tenants work together to try and achieve a manageable rent deferment with a reasonable repayment schedule, ideally with interest on it. So say we've gone down that route and we're just not getting anything out of the tenant, what are the other options that we might be able to use to get some cash back in our back pocket?
Well, as we know, cash is king. So, in practical steps, rent deposits. If landlords have the benefit of rent deposits, this is the time to use them. So, what you want to do, if you've got one, 99% of the time you will have a rent deposit deed. Get these out, dust them off, have a look, see what they say. Exactly the sort of time to make use of these. I imagine a number of people would have been doing so already. Have a careful look, see what you're obliged to do. These will usually say something along the lines of having to give tenant notice under the term set out in the deed, is to tell them that you're going to do it before you do it, and give them a kind of like a final kind of window to catch up their payments. Also, the deposit deeds, they will generally have some top-up provisions in, and along the lines that tenants have kind of X period of days in which to top up the deposit held. Linked to this, if you have a sneaking suspicion that a tenant is probably not going to be able to make up the top-up payments in accordance with the timescales set out, then what you might want to consider doing is similar to the deferment agreement / letter that we've just spoken about. What you might want to do is to consider having a supplemental agreement or a side letter, just to set out in writing what you are realistically expecting, or what the tenant realistically expects to be able to agree to do in terms of topping up the money that you've just withdrawn. So rent deposits, get them out, have a look. Guarantors, again, I'm sure this is something landlords are very kind of conscious of. So yeah, depending on the guarantee agreement, this might be an express agreement that you've entered into direct with a guarantor standing for a tenant at the time the lease was entered into, or you might have a former tenant who has effectively become a guarantor by entering into an authorised guarantee upon his assignment, his kind of outgoing departure from a lease. So guarantee agreements, get these out. Again, look at them, see what you have to do, and at what point you are entitled to actually go to the guarantor and say, hey, tenant's in default, I need you to make this good for me, please. Linked to this, vaguely linked to this, Section 81 of the Tribunals, Courts and Enforcement Act. Again, sure, landlords are aware that if you have a tenant who has granted a subtenancy, this creates an ability for you to go to the subtenant and say, hey, I'm not getting the rent I needed, I was due to be getting from your landlord. How about you pay your rent to me? Except, of course, the Act makes this all slightly more formal and obliges them to do it. So, again, if you're aware that that is the case, your tenant has a subtenant, take some advice on whether this is something that you can avail yourself of. Chances are it is. Come back, find out how to do it. As I say, these are all things where it'd be useful to take advice, and shameless plug, but this is what we're here to advise you on, and a kind of very brief, basic kind of summary there, but hopefully it's a refresher.
Thank you very much, Graeme. That's great. So what I'd like to do now is have a little bit of interaction. I'm going to put a poll up now, which will be just to get an idea whether how many of you have actually agreed rent deferments with your tenants, or if you're a tenant, if you've agreed a rent deferment with your landlord. So hopefully this will work. So shout immediately if it doesn't appear on your screen, and we'll just allow people to fill that in.
Personally, I don't have any tenants, so I'm going to say no.
Get a sense of where we are. Excellent. Okay, I can't see that we've got any more. Where are we? Can't actually scroll down to see what the results are. How infuriating. Right, let's end voting. Share results.
Oh, look.
There we go. Graeme, I can't see the answer. Can you advise?
Oh, I certainly can. So, in response to the question, have you agreed a rent deferment with your landlord in the last 2 months? 35% of respondents have said yes. 31% have said no. So we've got a third, and then presumably another third with who don't have tenants personally. Yeah,
okay, so that's really interesting. So out of the people that voted, approximately 50-50. So that's really interesting to know. Okay, lovely. Well, thanks ever so much for that, Graeme. I'm going to pick up now. Again, I don't wish to obviously go over things that people are already aware of, but sometimes it's useful to just reiterate what may be blindingly obvious, but just to cover the issue off. So in terms of insurance, obviously notwithstanding the current crisis, most leases, and I say most, leases will contain an obligation on the landlord to insure the building. Usually, even if it's a lease of whole, sometimes tenants are responsible for insurance, but mostly it's landlords. Unfortunately, even if the tenant doesn't pay your rent, your insurance rent, you will still have an obligation to insure the building. So it's imperative that that continues. I think the biggest risk here for both landlords and tenants actually is making sure that you liaise with your insurers to discuss empty properties. Obviously, we're now seeing a sort of staged return for some businesses, and no doubt tenants and occupiers will have their own regimes in place for inspection. However, I believe, and I'm hoping the insurers in the room won't disagree with me here, normally a commercial insurance buildings policy, it's normally between sort of 30-60 days for an occupancy. It's actually a much shorter period than residential policies, which have a much longer occupancy period. So you don't want to find yourself in a situation where your buildings insurance has been vitiated because the tenant hasn't been in occupation for that relevant period. I checked with the Association of British Insurers, and their advice is that as long as business owners have followed the risk management advice provided by their insurer and have taken reasonable endeavours to ensure the premises are suitably secured, then they will still be covered. But I must stress this, it's on a case-by-case basis. So where you have a specific property that is perhaps high risk, if you've got flammable materials, gas bottles, specific equipment, that kind of thing, don't just automatically assume that that's going to be the case. It's something that you need to speak to your insurer about on a case-by-case basis. Okay, so business rates. Obviously, a lot of the COVID-linked support is linked to business rates. I'm not going to talk about that here. It's just really a kind of summary of the support offered in terms of business rates relief. Again, this is more important for tenants and occupiers. Originally, in March, the initial announcement was that businesses in the retail, hospitality and leisure sectors in England wouldn't have to pay business rates for the 2020 to 2021 tax year. And they listed those examples: so shop, restaurant, cafe, bar, pub, cinema or live music venue, assembly or leisure property, so sports clubs, gyms, bars, and hospitality properties. So, for example, a hotel, guest house or self-catering accommodation. Then actually later on they produced some further advice, because the sort of the shop definition was actually, people were saying, well, what constitutes a shop? So they went on, and there's actually a really detailed piece of guidance on the government business rates sort of website that says what is included in the definition of a shop. So they expanded it to include things like opticians, markets, art galleries and estate agents as well, and further expanded it to include childcare and nurseries. So most professional service industries, like lawyers, aren't covered, but you've got the exception of things like opticians and nurseries that do fall into that category. So it is worthwhile checking out that full definition of shop premises, just to see that whether or not you should or should not be covered. I suppose the only other thing to bear in mind, I know we've talked initially about forfeiting leases, and there may be some landlords out there that are desperate to until the 30th of June comes and they want to forfeit their lease of their tenant. But just to be aware that if you're thinking that you are going to get the benefit of this business rates, it specifically states that it must be for occupied, so premises occupied as a shop, restaurant, etc. So our interpretation of that is that a landlord wouldn't not benefit if they took the property back. They would only get the 3 months business rates deferment. So that's just something to bear in mind. If you do want to have a look at it in more detail, there is a recent government's website, which the link in the slides. The local authority should have automatically applied your discount already for the 2020-2021 period. So if you're not sure, dig out your business rates bill, have a look at it and see what it says. And if it doesn't, get straight on the phone to your local authority's business rates team and have a word. Okay, right, dilapidations. I think, as I expressed at the beginning, this is not meant to be a full kind of in-depth review of dilaps. We tend to leave that to the surveyors unless there's a dispute. It's more of a sort of hints and tips about what to consider if you've got a lease coming to an end, whether you're a landlord, whether you're a tenant, and some of the different approaches that you can take. I would always stress that if you want sort of specific advice, then a survey is probably the best way to go. But we thought this would be really useful as a very general overview. Oh, sorry, skipped ahead. Sorry, there we go. Right. So obviously, when you're talking about dilapidations, we're talking terminal dilapidations, not interim. The key thing is that you need to assess the state of property as at the lease termination date. So it's really important when you're thinking about preparing a schedule of dilapidations that you're able to get access to the property. So the biggest issue that we've got at the moment is that obviously access to properties are restricted, although I think from some of my surveying colleagues we are seeing more movement in that at the moment. So surveyors being allowed to go into properties with socially distancing and with appropriate measures in place. So that's the key issue at the moment. The other thing as well to bear in mind is the period for the service of the schedule of dilapidations. Now, again, this means getting out your lease, dusting it off and having a look, and seeing if there are any provisions in there about when a schedule of dilapidations needs to be served. Because obviously, if you've got a lease end coming up, you can't get into the property, there may be a deadline in your lease about when that schedule needs to be served. Unfortunately, the Coronavirus Act hasn't actually dealt with this. There are a number of property related issues that it hasn't dealt with. Planning for one, dilapidations for another. So whilst it's kind of dealt with the biggie in terms of rent payments and forfeiture, it hasn't covered off a number of other things that have time limits that affect properties. So right. So the thing is, so check the limitation period for service. If there isn't a time period in the lease for service of the schedule, then it's going to be as per the Limitation Act 1980, which is about 12 years. So you've got a bit of time. So hopefully we'll have some time to get caught up. But as I say, don't get caught out on the timescales. The whole point is that you need to try and record the state of the property as close as possible to the lease termination date. So you know it's going to be tricky. But as I say, we are seeing a number of local surveyors saying, you know, we can go in out of hours. It all depends. If you've got a tenant that's working in the property 24/7, then you're going to struggle. So in terms of practical steps, if you can arrange an inspection, please do so. The other option that you could consider is having a Section 18 diminution in value claim. So ordinarily, a dilapidations claim is based on the common law principle of damage to the property. A tenant has had a lease, they have not kept the property in the state of repair as required by the lease, and the landlord is entitled to produce a schedule to show that damage and then claim those damages back from the tenant. There's a whole dilapidations pre-action protocol that goes with that. The alternative is to carry out a Section 18 of the diminution in value claim. So that's under Section 18 of the Landlord and Tenant Act 1927. And essentially what that says is that no claim for damages shall be in excess of the diminution in value of the landlord's freehold interest. And tenants use this quite a lot to try and knock landlords' dilapidations claims down a bit. I am advised that you don't need to have access to the property to carry out a diminution in value claim. So if you're a landlord, you want to get this settled, it might be quicker and easier to go down that route rather than try and fight it out and get, to get your full value of the schedule. So, that's something to consider. If you're a tenant, you're probably in the fortunate position that you've got keys to the property and you can get in, and so you are in the far better position to take a sort of schedule of the property if you're handing it back in the current pandemic. So if you can't get your surveyor to go out to the property to produce a full schedule, or you don't feel that it warrants, that level of support, one of the things you can do is to prepare a schedule yourself. Again, it has its own inherent risks. However, if this is a route you want to go down, there's a really useful app called Site Audit Pro, and it's about $12.99 on the store, and you can use it on your phone. You can go around and take photos. It will allow you to circle areas needing repair and then write commentary underneath. As I say, it's no substitute for a full surveyor schedule, but it will help you to produce a very comprehensive and written schedule of the state of repair, for your own records, and you can then send that on to the landlord if there is an ongoing dispute. Again, tenants can also consider Section 18 diminution in value claim, or a colder bank offer, which is a sort of without prejudice offer in relation to dilapidation specifically, that is open on the table for a specific time period and can have an impact on costs. So if the tenant were to send a colder bank offer for a fair and reasonable amount, rather than doing a full survey and getting into an argument, they could sort of say, well, look, this is the amount we're going to pay you. It's open for this period of time. And, the landlord may be more obliged to take that, it's on the table, ready to be accepted. But again, colder banks are tricky to draft. So again, take advice either from a lawyer or a surveyor if you want to put forward a colder bank offer in relation to dilapidations. We've got a question from Chris I've just seen come through.
Yes, I was just looking at that.
21 period, do you benefit from not having to pay rents? You said rents, but I'm assuming you mean rates, because that was the section. No worries. I don't know. I guess it would massively depend on whether the property was previously occupied for that specific purpose under the use classes order. So if it was a pub and you were buying it as a pub and you're opening it as a pub, I would anticipate it probably would apply, but it's probably something I would need to check. But good question.
I think anecdotally, purely anecdotally, I was having a conversation with a client who yesterday, and he has a number of premises in and around this area, and that have been used as kind of takeaways and so on. Fish and chip shop. I'm fairly certain there hasn't been a fish and chip shop kind of operating from these premises for some time, but nevertheless thought it might have a go at trying to claim rates relief on the property, and got knocked back fairly hard. So
Okay.
on the basis that he hadn't been on the register as being the rate payer, and so
Right.
therefore didn't qualify,
Because
but
it was a new
for the
applicant.
relief. Yeah.
Right, okay.
Um,
Chris, I would suggest if you want a definite answer to that question, it's probably best to pick up the phone to your local business rates department in for your local authority, because they are going to be the ones best placed to give you the answer to that question. Because it may vary on a local authority to local authority basis. So,
mm,
right. Moving on, so I'm going to pass
woohoo.
back to Graeme, who's just going to talk briefly about the impact of the Coronavirus Act on 54 Act lease renewals. It's got a little bit of an impact there, and then finally we'll move on to breaks and other ways a lease can be terminated. So I shall pass that to Graeme.
Thank you very much. Okay, so just touching very briefly on the way that the Coronavirus Act impacts on 54 Act renewals. So, as we all know, protected tenancies have a right to renew generally, but the principle is they have a right to renew their lease at the end of its term on substantially the same terms, save where either party has a reasonable reason for introducing a variation. So, as we know, landlords, the number of grounds set out in the 54 Act on which a landlord can purport to resist a tenant's application for a new lease, one of these being the Section 30, subsection 1B ground, that being persistent delay in paying the rents due under the lease. Now, what the Coronavirus Act does is to say in a slightly predictable way that any failure on the part of the tenant to pay the rent during the relevant period, i.e., up to 30 June, cannot be used against him if he were to make an application for a new lease. So it's just another one of the kind of sticking plaster kind of provisions, in as much as we know that delay in paying rent prior to the relevant period starting is probably still fair game, and likewise again, once we're out of the relevant period post 30 June, assuming it isn't extended, then delay in paying rent again after that date presumably is that just then going to kind of kick back in and will be available as something a landlord can
Yeah.
point to.
I
Comments.
think the whole point with this, Graham, was that I think the whole point with it was that they didn't want the sort of rent payment over the relevant period to be used as a kind of cleaver just to get rid of tenants that the landlord didn't like it. But it's only meant to cover that sort of troubled relevant period,
Yeah.
essentially. So if you've had a tenant that has been absolutely awful in paying rent over sort of 3 of the 5 years of the lease, then there is nothing in this provision that is going to prevent you from using that ground as a reason for refusing as a new lease. But obviously, please bear in mind that that ground is a discretionary ground, so it is going to be down to the discretion of the court whether or not they're going to grant you that.
Perfect. Okie dokie then. So I think that now takes us over the page. So other things we can do, other ways people might be looking at trying to extricate themselves from a lease. Break clauses. Everybody loves a break clause. Useful for both landlords and tenants. Generally, as we all know, there's going to be a degree of preaching to the choir here. Break clauses generally date specific, will generally specify dates on which and by which things have to be done. But again, leases vary, and who knows, sometimes you get all kinds of things popping up from time to time. So again, as with everything else, get the document out, dust it off, and have a look, see what you need to do. You might find that some tenants might find they have the benefit of a rolling break clause once they've got up past a particular point in the lease, but get the document out, have a careful look. So the thing with serving a break notice is to check again. Yeah, occasionally this can go wrong. It is a frequently litigated area, so get the lease out. As I've said, at danger of risk of repeating myself, get it out, check it. So if you're this more particularly applies to tenants serving a break notice. It's something that anecdotally you hear of people sometimes overlooking. And make sure you serve your break notice on the right person. um, so it's obviously a tenant. I mean, the identity of a tenant is going to be reasonably well known throughout a term, and you would imagine that most tenants are going to be kind of cognizant of the fact that the party that they're paying rent to during a lease changes. They're going to be aware of that, but occasionally it does get overlooked, and people do seem to occasionally forget to check who is currently entitled to the reversionary interest, So check. Again, sometimes leases set out a specific form of break notice that's got to be used. Sometimes they don't, but check. So yeah, just be careful. And otherwise, interesting point, something again that I suspect the vast majority of people kind of sitting on the webinar are aware of. If you're a tenant, maybe not so much though. Be aware that unless you have a lease that specifically says that rent that you've paid that relates to a period after the break date is to be refunded to you, unless you have a lease that specifically says that, your landlord isn't under an obligation to refund that rent to you, which is hugely unfortunate to say. If you want to, you've got a break date of you've got a break date that's effective on, say, the 1st of July, but you've got a rent payment date on the 30th of June, you've still got to make your full rent payment on the 30th of June, if that's what the lease says, and there's no presumption, no automatic presumption the landlord has to actually give it you back in respect of the period after the break date. And we had that quite a big case about that a couple of years ago, Marks and Spencer's and BNP Paribas, which kind of made this abundantly clear. Seem to have caught M&S out.
So what about what other options have we got potentially, or not got potentially, to bring a lease to an end?
Okay, we're heading into spurious and tenuous territory now. So one thing that at one point we thought people might be trying to kind of make a case for. We thought people might try and say, my lease has been frustrated. Therefore, I should be released automatically from all my obligations and be allowed to walk away. So, what is frustration? Well, obviously, yeah. So, in English law, we have the concept of frustration. Now, I've had to write myself a little note as to exactly how this breaks down. So, in English law, this is a concept where the circumstances in which people now find themselves are beyond their control and were outside their contemplation at the time they've signed up to particular obligations under the contract, which they're now talking about. And those circumstances, they would now argue, make that particular contract impossible to perform. So essentially, it's a relief. It's a remedy that's a discretionary remedy that's available from courts. It goes way back, and it was essentially, it came about where people were finding themselves in a situation where, due to circumstances beyond their control, out of their control, totally unforeseen, they found that what they thought they'd signed up to just wasn't possible. And occasionally, and rarely, courts would agree with them that, yeah, okay, you aren't in the position you thought you were going to be in. We agree that it's clearly unreasonable, and we're going to release you from your contractual obligations. So, one bit of comfort that we have here is that we know Thank you, Nick. Good question. So what we know is that there has yet to be a single case in which any kind of English court or any kind of court of another country which derives its case law from our jurisdiction, yet to be a single instance where a lease has been held to be frustrated. As a rule of thumb, it's going to be tremendously unlikely that a court is going to agree that it's just seems to be incredibly rare. I mean, we have it. I mean, Nick's asked if we can give a plausible case where frustration might be upheld, or held to a court might agree that a lease has been frustrated. I mean, based on the case law so far, good question, War. But based on the case law that we've got so far, so this is the European Medicines Agency before the Brexit vote, but during the period during which everyone was going through the I was going to say marketing, but that's not quite the right word. But people making their representations and putting their cases for and against the referendum. So during that time, whilst that was going on, the campaigns were underway. The European Medicines Agency entered into a new lease of some costly premises on Canary Wharf, aiming to use that as what they thought was going to be their European headquarters. Then, of course, we had the referendum result, and they decided that it wasn't a great plan. So they went to court and said, well, hang on, surely our lease has been frustrated by this. And the court said, well, hang on, no. This would have been, this could have been within your contemplation at the time that you took this, or at the time that you signed up any agreement related to it. But no, this is insufficient. So Brexit wasn't good enough to be a frustrating event, and that was quite a big one. War, again, I think the English, it's an interesting one. I think we are probably anticipating that there is going to be litigation here. It's going to be something that we're going to see people coming back to. It might raise its head, and potentially there could be some very interesting, but kind of brackets read costly litigation comes out of this. It's going to be interesting to see. War is something that you might more commonly have fitting into a force majeure context, which is where we go over the page. So another thing that people thought at one point might be relevant. So occasionally, people on this are going to be aware of the concept of force majeure. It's similar to frustration, but sometimes you'll see in agreements, not so much, very rarely in leases, haven't actually seen it in practice. In contracts, you will sometimes kind of come across a force majeure provision. So this is more kind of common to happen in a situation where you've signed up to a contract and you say, right, I'm going to do something by a particular time, such as say potentially carrying out some works to a property, but hey, in the event that something happens which delays me doing this, I need to have some kind of comfort and certainty that I'm trying to think of a way of putting this, I'm not going to get hammered here in the event that I can't meet that timetable due to something that happens beyond my control. It's tempting to say due to something frustrating happens beyond, but it's not quite the same thing. So occasionally if you see a force majeure clause, that's the sort of thing where they can come to light. A force majeure clause, but in order to be able to rely on them, though, the wording in the clause needs to be specific. So, say if you were going to say that, I don't know. I mean, it's so if you were, say, a landlord, you were going to be carrying out some work on behalf of a tenant. I mean, perhaps a kind of antecedent to taking a lease, antecedent to the tenant taking a lease. Might say you might have something along the lines that, save where materials aren't available, you can't hold me to a timetable. Save where workers aren't available due to something beyond my control. That's a sort of instance of a force majeure. Again,
but normally, I was going to say, because people are going to say, well, I might have that, but actually, what we're seeing is the advice is you would almost need to have a specific pandemic clause. It wouldn't be enough to say workers aren't available. It would need to be absolutely specific. Actually, I think this is going to be a massive area because historically, leases have not had force majeure clause in it. And I think moving forward, I think we're going to see a lot more of those coming into the drafting of leases, because it's going to give people options and things like that. So
Absolutely, yep, completely.
okay. Any more from you, Graeme, or are you finished on that page?
No, it was a good page, but I think I'm happy.
Excellent. Okay.
Oh, we've got a question from Canal.
Yes, I've just sort of asked everyone to stop because we are actually now at the questions page,
Ah,
the appropriate
ah,
time. I just thought rather than it sort of putting
mm,
you off your flow, we would wait until the end to answer questions.
good.
Um, Yeah, we've got some really good ones. I think if we can go back to Nick's question about frustration, it's such a specialist area, Nick. An example would be, for example, there was a 1930 case where the court considered the effect upon a jockey's contract for personal services on the death of his employer, a racehorse owner. The court held that death frustrated his jockey's contract with him, since the contract created a relationship involving mutual confidence. But that's just one example. It is a highly technical and specialised area. And as I mentioned at the beginning, my colleague Graeme Mead in our commercial dispute resolution team, it's his topic of choice. He absolutely loves the topic of frustration. He's written some cracking articles. So if you want to have a look on our Prison's LinkedIn page, he goes into this in a lot more detail there. So, right, let's go down through the list. So, Conal's question, are leases require the tenant to have complied with lease terms, including payments of rent? Would COVID act to negate this obligation? I'm assuming, Conal, that you're talking about in the exercise of a break clause. Your answer is yeah, absolutely. If the tenant hasn't paid the rent and a condition attaching to a break clause obliges compliance with these covenants and payment of rent, the most common conditions attaching to break clauses that we see are must have paid the rent and can't have any continuing subtenancies. And then some other leases normally go on for, compliance with covenants or material compliance with covenants. So yeah, that's a massive disadvantage for you as a tenant. If you haven't paid the rent and you want to exercise a break, you're going to have to pay it. Plus, obviously, any interest that you've not paid. If there's a clause on paying interest, that's how technical a break clause is. I can't remember the name of the case, but there was a case where a tenant had paid the rent predominantly on time, but they made sure that they paid it up to the date. They complied with their covenants, but because they hadn't paid the landlord interest on the late payments of rent, even though the landlord hadn't demanded the interest, the court held that they were unable to exercise the break clause. So it is a really, really high standard for tenants being able to exercise break clauses. So if you're a landlord and you've got a tenant with a break clause, then yes, they have to cough up and pay you the interest, but you don't have to send them an interest demand. So there you go, make the life more difficult if you don't want them to stay. So Howard, if you enter a deferment and the company goes into administration, would the administrator have to pay rent from the date of the administration as a cost of the occupancy? Does the deferment transfer to the administration? That is a very good question, and I'm going to be honest, I don't know the answer. Graeme, do you?
I'm guessing that in a deferment, if you were drafting the deferment
It's
properly,
a
I guess
contractual
you could say,
obligation.
but I guess if you said that the deferment was personal to the tenant, then
Yes,
and
absolutely.
then so yeah, then you can get them to pay. Make sure you do that. Make sure you come to us to have your deferment grant drafted.
Um, so yeah, we were talking about some of the things that you would want to put in a rent deferment. One of those being, broadly speaking, when the deferment would come to an end. The template that we have here includes where the tenant is wound up, so that would automatically end the deferment anyway. So as long as you've got that in there, then I don't think an administrator would be bound, and it's effectively a deferment is a side letter. It does not. This is why we were saying it's really important not to do it as a deed. You then inadvertently formally vary the terms of the lease, and if you did that, and then an administrator came in, they would likely to be bound by it. So as long as it's a side letter, it's contractual between the between the landlord and the tenant. So we think that's probably that there. But as I say, if your deferment agreement provides that it comes to an end automatically if the company's wound up, then that would good. So Angus has asked the question, what about action for other breach of covenant?
I'm assuming that's forfeiture.
Yeah.
You can still do it.
I think you can.
It's all systems go on forfeiture for anything other than. I mean, my understanding was that the coronavirus. I mean, the whole kind of point of it was, I think it was the government saying, "Hey, everyone's going to run out of cash," but it's not to say that they're not necessarily going to run out of cash so much that they're going to breach their repairing obligations. Say that's what you're thinking of. I think it's still go on forfeiture.
The overall guidance we have for tenants is that even if you don't pay your rent, you still have to repair the property. All of the other obligations under the lease still continue. I mean, the obligation to pay rent still continues. It's just that the landlords are prevented from taking any action mostly action to recover that money or to actually gain access to the property and to bring the lease to an end by frustration. So absolutely, if you've got a tenant lease that provides the tenant's got to keep the property in full repair and there's a tree growing out of the roof, then that's definitely something that you can still carry on with. The difficulty that you might have is getting access to the court. And that's the biggest issue at the moment as well. So by all means, get the wheels in motion, but everything is sort of slowing down there at the moment. So hopefully we'll see some of that starting to improve. Okay. Do we have any more questions? Any more? Should wait for people to ask. Well, just while we wait to see if there's any more questions, we're almost coming up to the hour, so there we go. We did quite well on that, including questions, didn't we? So just a reminder again, Amy Ellis will be sending you a copy of the webinar today, a copy of the slides and a feedback form to fill in. We'd love you to fill in the feedback form. This is the first webinar that Graeme and I have done. So, please be honest, but perhaps kind.
Not too honest.
Kind. We can, but we are obviously keen to know if there are areas of improvement, if there were things that you liked, things we could do better, then please, it's really valuable for us to do that. Again, please remember about our COVID Assist program, 1 hour of free advice for any businesses or clients that are affected by COVID-19. So, please do give us a call for that. Graeme and I are here. We have deferment agreements ready to go that we can sort out for you. We can give you advice on exercising break clauses. We can give you advice on, service provisions for dilapidations. All you got to do is pick up the phone. We're here. We're all working from home, as you can see, my lovely kitchen. So we're agile and we're on board and we're able to support you. So, thanks, Nick. Some thanks. That's lovely. Yay.
Taking that.
Excellent. Good. Also, if in your feedback forms, you can let us have ideas about any other topics you'd like us to give webinars on, then we can take that on board and produce some more webinars for you. As I mentioned at the beginning, we're potentially looking at doing a sort of more litigation hints and tips, property litigation hints and tips towards the end of June, as that's when we anticipate there's going to be quite a lot of litigation coming up, and we will await avidly to see if there is an extension to the relevant period to see whether or not this is going to be pushed down the line. I hope not. Thank you all. So yes, we will call that a day now. Thank you for joining us. We really loved having you here. Drop us a line, just so you know. I'll just put the last slide up. So that's my email address and Graeme's email address. On our office numbers, we've got them set automatically to our mobiles. So if you do ring the office number, it will come through to me on my mobile here, or you can drop me an email. But so thank you, everyone. Have a lovely afternoon. Have a great bank holiday weekend, and join us again for the next presentation. Thank you.
Okay.